Good afternoon, and welcome to Division 7 of the Court of Appeals. My name is Tony Navarro. To my right is the Honorable Jerry Jones. To my left is the Honorable Alex Martinez, a senior judge who we are pleased could join us today. We have two cases on our 9 o'clock docket, People v. Ambriz Serrano and Parks v. Parrish. Are counsel for both cases present in the courtroom? Thank you. I'll direct my comments to all of you. Just for your information, we'll be taking a short recess after the first case to reconstitute the panel for the second case. The attorneys should have received written instructions explaining our oral argument procedures. If the attorneys at the counsel tables have any questions about our procedures, you can ask them now. Seeing none, I'll remind you that you have 15 minutes per side. Appellant's counsel could try to preserve argument for rebuttal, but I ask you to keep track of your time with the clock on the lectern. Remind both counsel that these proceedings are being live streamed on our website and are also going to be archived there. So please maintain the confidentiality of any juveniles' names, sex assault victims, and any other information that you do not want publicly released. Also, when you get to the lectern, please identify yourself by name and attorney registration number. I ask everyone in the courtroom to turn off any cell phones or other such devices so they will not disturb the arguments. With that being said, I think we're ready to hear arguments in People v. Ambriz Serrano, number 17CA1257, and counsel may proceed when ready.
Good morning. May it please the court. My name is Brian Cox, registration number 50258, and I represent Ms. Mercedes Ambriz Serrano. I'd like to focus on the first two issues in the briefing, both of which hinge on the intent to defraud element. So beginning with the sufficiency issue. The state had to prove not only that Ms. Ambriz Serrano passed a written instrument that was false, but also that she did so with the intent to defraud. Now, that term intent to defraud or the word defraud itself are not defined in statute or case law. So turning to dictionary definitions, these definitions all incorporate some sort of loss or harm to the defrauded party. For example, the Black's Law Dictionary is to cause injury or loss by deceit. The fraud definition is to induce another to act to his or her detriment. The Merriam-Webster definition is to deprive of something. Even the definition proposed by the state is to take or withhold something. So it necessarily involves not only gaining some benefit, but causing some sort of loss or injury on the other side. And there was simply no evidence here that Ms. Ambriz Serrano had that requisite intent to cause any sort of loss or injury on the part of the produce company. And the produce company was, after MJOA, the only named victim left. So if this court looks at existing forgery case law, that case law basically falls into two buckets. The majority of these cases involve some sort of direct financial gain, cashing a forged check, using a stolen gift card. If you took that to the employment context like we have here, that would be something like filling out a false timesheet, something in order to get money that was not earned. This case does not fall into that because there's no evidence that Ms. Ambriz Serrano did not do the work for which she was being paid. Then the other set of cases, a smaller set of cases, involve exerting some sort of influence on a public servant. So Kuhn affair was a forged letter to a district attorney trying to get charges dropped. Tucker was a forged letter to a judge threatening criminal charges. Both of those went to causing some loss or injury to that public office that was being improperly influenced.
What's the loss to the public office in either of those cases?
Well, it's an injury to their duty, so their duty to uphold and enforce the law. So that duty was being interfered with.
Well, here, doesn't the employer have an obligation, at least under federal law, not to hire somebody who's undocumented? And doing this interferes with that duty.
The produce company does have an obligation under federal law to do that, but it's not clear what Ms. Ambris-Serrano actually knew because it requires an intent to defraud. So it would require that she knows that she's causing some sort of harm to the produce company.
But can't her intent be inferred from the very act of using these false documents that she knows to be false and submitting them to the employer?
So from that, it could be inferred that she knew a number had to go into that box. It's not clear that she knew that by putting a number into that box that she was causing any sort of harm to the produce company. There was simply no evidence that she knew that that would be the effect of doing so. And moreover, while many cases, or at least some cases cited by the state, do say that the intent to defraud can be inferred from passing the false instrument, those were all cases where the harm was obvious. So things like cashing a forged check, it's obvious that by cashing a forged check, you are taking money that is not yours. So it is true that the intent to defraud can be inferred there, but here it's not nearly so obvious that there is an intent to defraud based on these facts.
Do you have other examples of when you would not infer from the, or were not able to infer from the act the intent that's required?
Off the top of my head, I haven't thought of other examples. I suppose any situation, perhaps.
Now, it's only an inference, so I mean, the argument you're making is clearly one that could be made to a jury, but you're suggesting it's insufficient because this seems to be somewhat of an exception that you cannot infer from the act the intent.
Yes, in these situations, in this situation, my argument is that the intent cannot be inferred from the act without some kind of evidence that Ms. Ambris-Serrano knew that she was causing or could potentially be causing or wanted to cause some sort of loss or injury on the part of the produce company. But in terms of an argument to the jury, I'll move over to the second issue because that is about how the jury was instructed, unless the court has other questions on the sufficiency issue. So the second issue was precisely about what could be argued to the jury. So Ms. Ambris-Serrano tendered 3 instructions on mistake of fact as an affirmative defense. The trial court denied all 3. What's at issue here is the third one. And so the third of those instructions said that with regard to the affirmative defense of mistake of fact, the jury must apply a subjective standard. I won't read out the entire thing, but that if Ms. Ambris-Serrano believed that she was not defrauding anyone or was not causing any harm, then that negates the intent to defraud element and the jury should acquit. That was the gist of that third instruction. Now, that third instruction, if you simply delete the first clause that says with regard to the affirmative defense of mistake of fact, this becomes a legally proper theory of the case that Ms. Ambris-Serrano should have been able to have the court instruct the jury on. So under the Colorado Supreme Court's precedent in Nunez, when an instruction is tendered that puts the trial court on notice of what the theory of defense is, if the trial court, for whatever reason, will not give that particular instruction, the trial court then has an affirmative duty to work with defense counsel to come up with some sort of substitute.
How is this a mistake of fact case at all? Seems like maybe it was a mistake of law, but that's a different animal.
Well, this is why I did not raise it as that instruction should have been given as an affirmative defense. Mistake of fact as an affirmative defense, Ms. Ambris-Serrano concedes that that doesn't apply here. But when you look at the actual text of this instruction and the theory that it outlines, other than that very first clause that uses the term mistake of fact, this explains the theory of the case, and this explains a viable path to acquittal for Ms. Ambris-Serrano. Both as a matter of law and as a matter of fact. And so under Nunez, Nunez was procedurally almost identical to this. The defendant had tendered an affirmative defense of alibi. The trial court had rightly concluded that that could not be given as an affirmative defense in that case, but took no further action. And there, the Supreme Court concluded that the trial court had a duty at that point to look at those instructions, see that there was really a theory of defense there, and work with trial counsel to come up with a valid theory of defense. So the same principle applied here. The state is arguing that this is reviewed for plain error because it wasn't tendered as a theory of the case, but this is the exact same procedural posture as Nunez. And so review should be de novo, and Ms. Embry-Serrano should have gotten that instruction. Furthermore, that error was not harmless. The arguments, it is true that Ms. Embry-Serrano was able to argue the same point to the jury, but the arguments of counsel are not an adequate substitute for instructions given by the court. If they were, then essentially all instructional errors would be harmless as long as defense counsel is allowed to argue, and that is not the law in Colorado. It is exceedingly rare that this error occurs and appellate courts conclude that it's harmless, precisely because getting that instruction from the judge is significantly more impactful than hearing it in closing argument. Getting it from the judge means the jury is able to take it back into deliberations. It at least has sort of an implicit endorsement by the judge as being a valid theory, not necessarily one that the jury has to adopt, but a valid one that it can consider. Did you have a question?
Thank you. Why is the instruction that intent to defraud is an element of the offense not a sufficient instruction? Or in other words, isn't this defense just a denial of that intent?
It is a denial of that element, but it goes into quite a bit more detail about why that element was not proven. And that's particularly important here where intent to defraud or defraud were not defined in any other way. So it was really left quite open what those terms meant and what evidence did or did not support them. So this instruction explained that because she didn't know the number belonged to anyone, didn't know it would cause any harm to use it, that she did not form that requisite intent. And the Nunez court and several other decisions have held that simply outlining the elements of the offense is not an adequate substitute for a proper theory of the case instruction. If the court has no other questions, I'll reserve the rest of my time.
You may. Thank you.
May it please the court? Elizabeth Ford Milani, registration number 48843 for the people. The people respectfully request that this court affirm the judgment of conviction. I agree with opposing counsel that the sufficiency and the theory of the case issues in this case are somewhat intertwined because they really turn on what is an intent to defraud. And I think in this case, intent to defraud, as has been discussed in other cases where that intent may be inferred by the passing of a forged instrument, does not require an intent to cause a harm or loss. Now, there is no doubt that in many of these cases from the Court of Appeals and from the Supreme Court that some sort of harm or loss occurs. But I don't think that the intent to defraud, as it's defined in the Third New International Dictionary, requires that intent to cause the harm or loss. The intent is to take some right or possession by perversion of the truth, deception, trickery, things of that nature. And I think it's important to look at the Tucker case. Again, the Tucker case could have involved harm to the duty of the court, to an attorney, but there was no discussion that that was the intent at issue in this case. The Court of Appeals, in that case, Judge Richman, just wrote that the defendant's intent is amply evidenced by the forging of the attorney's signature. And that's what we have in this case. I think that the defendant's intent can be inferred from the actions in this case, and that was the intent to defraud. I think that this should be reviewed for plain error. Obviously, this is not a typical garden variety sufficiency claim, but the type that involves statutory construction. This case, or this issue, whether it's plain error or not, has divided this court, but the state's position is that it should be plain error, that this interpretation requiring some sort of intent to cause a harm or loss not be adopted in this case.
Even if we agreed with you on the standard of review, assuming it's not preserved, if the evidence was insufficient to satisfy the statute, how would it not be plain error?
I think it comes down to the obvious prong, and that was talked about in the Localo case, where no case that I've found in Colorado has interpreted such a definition. And I don't think it's obvious in the sense that it is the plain meaning to cause an intent, or an intent to cause a harm or loss, given that the Webster's Third New International Dictionary does not incorporate that definition. So I don't think it would be obvious under that prong, so it wouldn't rise to the level of plain error in that case.
Thank you.
If there are no further questions with regard to the sufficiency and the intent to defraud, I would like to talk about the instructional issue in this case. So the trial court properly declined to give this affirmative defense instruction because it was incorrect, as opposing counsel has discussed. And the trial court thereafter was not under a duty to craft a theory of the case instruction to act as an advocate for the defense. I disagree that the posture here is the same as in Nunez. I think the language of Nunez suggests that the instruction given in that case was supposed to be a theory of defense instruction. And I say that because there's a reference to the Huckleberry case that sort of makes that distinction, but also the fact that the Supreme Court in Nunez talked about how the tendered instruction only suggested it was an affirmative defense. Here, there was no suggestion. The instruction that was tendered by opposing counsel said, with regard to the affirmative defense, it was structured in that way. So I think that for the trial court to have had taken this affirmative defense instruction, it was discussed as an affirmative defense instruction. The colloquy with the court was about the affirmative defense instruction. To have taken that and then changed it into an appropriate theory of the case instruction is beyond the language of Nunez. I also think that for the reasons that I've talked about in the brief, the assertions that are made in that theory of the case instruction don't necessarily pertain to intent to defraud. The prosecution was not required to prove that defendant knew that the Social Security number belonged to someone. Didn't pertain to intent to defraud. The prosecution wasn't required to show that the Social Security belonged to anyone or as to how that wasn't obtained. It just wasn't pertinent to the intent to defraud. And so to make this a proper instruction, the trial court would have had to do more than simply change the first few words and switch it from affirmative defense to theory of the case. I also think that if this court discerns any sort of error, it was harmless. The defendant's theory was clearly on display for the jury, from the opening statement to the closing argument. Defendant's theory was that she lacked the intent to defraud because all she wanted to do was work. She didn't want to hurt anybody, but she knew, in fact, that this Social Security number did not belong to her. So I think that this court can find it harmless in any event, even if it discerns some sort of error in this case, but I don't think there was an error. If there are no further questions with regard to the instruction, I just want to briefly touch on the prosecutorial misconduct issue and the suppression issue. With regard to the prosecutorial misconduct claim, I don't think that a fair reading of the prosecutor's rebuttal argument can be understood as denigrating the defense in any way. Instead, understood in context, which is how this court reviews closing argument or challenges to closing argument, the prosecutor was merely setting up potential problems, i.e. the lack of the requisite intent, and then going through the evidence that showed that intent. And I think in this case, it's the prosecutor's intent in making these statements was not to denigrate or somehow belittle opposing counsel or the defendant herself. Finally, turning to the custody issue, the Miranda issue, as I talk about in my brief, many of the factors that the court discussed in its ruling fell in favor that there was no custody in this case and that ruling should be upheld. Therefore, all of the statements that the defendant made in the second interview were properly admitted and before the jury. I think one of the biggest factors that favors a non-custodial finding in this case is the fact that the daughters were present during the interview. cases that have interpreted Miranda have talked about Miranda was really this, was a decision to protect against this coercive force where suspects are removed from friends or family or anyone, and those outside, and in doing so, there are outside pressures. And so I think that because the daughters were present throughout the entire interview, that cuts strongly against a finding that a reasonable person in that scenario would find that their freedom of action was curtailed to a degree associated with a formal arrest. If there are any other questions that I can answer for the court.
Looks like there aren't any. Thank you,
Thank you.
counsel. Mr. Cox, you have 4 minutes and 18 seconds.
Thank you, Your Honor. Beginning with the sufficiency issue and whether plain error review applies and how that affects the analysis, if so, I would first note that literally as we speak, the Supreme Court is hearing arguments on this issue. But for now, the situation that we have is that the weight of authority within the Court of Appeals is that plain error review does not apply to sufficiency claims. But even if this division follows the Locallo division and concludes that it does, an error can be obvious when it is based on simply the plain meaning of a statutory term. There does not need to be a case on point. There does not need to be a statutory definition. And here, as I've explained, all of the dictionary definitions incorporate some concept of harm inflicted on the other party. So the obviousness is there, and I think it's fairly obvious why it is also substantial. The state also talked a little bit about how intent can be inferred from passing an instrument. As I said, there are cases that say that, but context is important. Those cases were all ones where the harm was obvious from passing the instrument. That the same thing is not true here. And the intent to defraud element has to mean something other than simply passing the instrument. Otherwise, that element would just always be proven. That element would really be rendered superfluous.
But counsel, here we have a situation where the passing of the instrument places the employer in jeopardy, in legal jeopardy.
That
Why
is
it-
true.
Why is that different than the public cases you referred to earlier?
Because it's not clear here that Ms. Embry-Serrano knew that or that that was her intent. And because it is a question of her intent, it's a subjective standard. It's about her. It's not about objectively what the employer was actually exposed to. Also addressing the Tucker case, the analysis there was quite brief. And when the intent element was discussed, it was being discussed in tandem with the intent element of attempting to influence a public servant. So I don't really think that that case provides a whole lot of guidance, given how cursory the analysis was and given that the analysis sort of lumped the two offenses together. Then turning to the instructional issue, the procedural posture really was the same in Nunez. Without actually having a copy of the instruction in Nunez, I can't comment on how clear it was, whether it was an affirmative defense there versus here. But the Supreme Court treated it as an instruction that was improperly tendered as an affirmative defense. And yet still that triggered the trial court's affirmative duty. Here we have the same thing, and we also have an instruction that if you simply read it, again, aside from those very first few words, it's very clear that that instruction is spelling out a theory of the case. The trial court was fully on notice that that was a theory, and it was a theory that Ms. Embry-Serrano wanted the jury to have in front of them.
But counsel, how is it a theory of defense? Because how are these facts defenses to the charge? They don't
Well-
have to prove that she knew it belonged to somebody else. They don't have to prove how she obtained it even. I mean, so how is this a defense to anything?
Well, those facts are relevant to her intent, because if she doesn't know that she's causing any sort of harm, if she doesn't know that there's some other person whose number this is who it might affect, if she doesn't know that the produce company could get in trouble for this, then that negates that element.
But none of that's explained in the tendered instruction. See, I mean, you're asking the trial court to put a lot of pieces together, it seems to me.
Well, I think when you read that tendered instruction, it says that it's based on her subjective belief, and then it lays out certain facts that show that her subjective belief was that she was not defrauding anyone. And so I think that really that does spell out the theory quite clearly. And so I would ask this court to either vacate or to reverse Ms. Embry-Serrano's conviction. Thank you.
Thank you, Mr. Cox, and thank you to both counsel for your arguments. They are helpful to the court. The case will stand submitted and a written opinion will issue in due course. Counsel in this case are excused, and we will now take a short recess to reconstitute the panel for the second case, and the bailiff may so announce.
All rise. The court is returned from recess. Please be seated.
Good afternoon, and welcome back to Division 7 of the Court of Appeals. Again, my name is Tony Navarro. To my right is the Honorable Jerry Jones. To my left is the Honorable James Casebolt, a senior judge who we are pleased to have with us today. We are now ready to hear arguments in Parks versus Parrish. If the attorneys at the tables have any questions about our procedures, please ask them now. Seeing none, I remind you to identify yourself by name and attorney registration number when you reach the lectern. I remind everyone in the courtroom to turn off any cell phones or other such devices. And also I remind appellant's counsel that you have the opportunity to save time for rebuttal, but please keep track of your time with the clock on the lectern. With that, we're ready to hear arguments in Parks versus Parrish, number 17CA1257, and counsel may proceed when ready.
May it please the court, my name is Logan Martin, 44148, appearing on behalf of the plaintiff appellant James Parks in this matter. I will attempt to reserve 3 minutes of time for rebuttal, realizing that it's my responsibility to keep track of that time. This is an appeal from a series of directed verdict motions in a legal malpractice case involving Mr. Parks and his former attorney, Mr. Parrish, and his law firm. In the briefs, we've raised 4 issues, and while I'm prepared to speak to all of them, I'm going to attempt today, given the time constraints, to discuss our first and third issues. That is the abuse of process claim and the attorney fee-based counterclaims. For those claims, we're asking for reversal of the district court's denial of the plaintiff's motion for a directed verdict on the counterclaims, as well as a retrial of the plaintiff's claims which were tainted with respect to the abuse of process claim. Turning to the abuse of process counterclaim, it's very common when we talk about that claim to describe the elements using a sort of shorthand in which we say that the elements are improper motive, improper use, and damage. But if you look at the repeated formulation of that tort in the case law, since we focus so much on the second claim, the words used there are pretty important. To prove an abuse of process claim, the claimant must show willful action in the use of the process, which is not proper in the regular course of the proceedings, i.e., use of a legal proceeding in an improper manner. And the case law bears out that this element is objective, that it involves showing that the tortfeasor did something that essentially no reasonable person would or should use in the process given. In this case, and the case law also bears out the idea that that's normally to obtain some collateral advantage not ordinarily includable in the process itself. In this case, at the conclusion of or toward the end of their legal relationship, the evidence indicated that Mr. Parks and Mr. Parrish found themselves in what's frankly a not uncommon situation between an attorney and a client. That is, Mr. Parrish believed that he performed services adequately, that he was entitled to a certain amount of unpaid legal fees for those services. Mr. Parks indicated that he did not believe those services had been performed adequately, that they'd been in fact performed negligently, and that the result to him was financial loss. The evidence also indicates that toward the conclusion of their representation, the parties had attempted to negotiate between themselves amicably and were unable to do so. That after doing so, Mr. Parrish sought to collect his fees using the attorney lien procedures in actually not the dissolution case, but the underlying civil action, and that after that point in time, Mr. Parks brought this action. It's important to note, though, that the steps taken, the filing of this independent action that is giving rise to this appeal, which eventually sort of consolidated the attorney fee lien claims as a counterclaim, was all done voluntarily. It's never been asserted or articulated how that those steps were improper or using a civil action for some kind of a procedure that a civil action should never be used for. We know from the case law that when a claimant is trying to show that a process was abused, that shows abuse of process, it's not sufficient simply to say that the claimant's claims were incorrect, unsuccessful. Or in fact, the case law goes so far as to say that absent improper use of the process, even where the claimant knowingly brings forward unfounded claims, which is certainly not something we'd concede is supported by the evidence even construed in the light most favorable to the defendants. But the Walker case and the ART case say that even when a claimant knowingly brings an unfounded claim, absent improper use, the abuse of process claim is not sustainable. What is sustainable in abuse of process claims, if you look at the case law, is things that are an attempt to do something not even contemplated by the proceedings. For example, filing a lis pendens or filing an action not because you think that, or not because objectively there's a valid basis for it, but because that can gum up a time-sensitive real estate sale. Bringing an action against one party when your real goal is to extort some kind of benefit over a third party. There's another example in the case, I believe it's the Aztec Sound case, where the civil action was really just leveraged to attempt to obtain increased rent payments or collateral advantages on a lease. In those situations, the objective improper use is taking some kind of step not included in the process itself, and that wasn't shown here.
Mr. Martin, can you think of any situation in which filing a malpractice claim against your attorney could be an abusive process?
If that claim is supported by, assuming, and I'm trying not to fight the hypothetical, assuming that claim is supported by expert testimony, certificate of review, and otherwise clears the bar of 13-17-102, I'd be hard-pressed to do so. I think it's possible, for example, if the real reason you're filing a claim against attorney one is to obtain an advantage against another attorney, or you can potentially conceive of some kind of more convoluted business scenarios between the attorney and the client. But generally speaking, I'm hard-pressed to do so. And I'm comfortable saying that because the reason we believe the district court erred and has kind of a significant policy implication in this case is that we already have in our statutes and in our case law a very good, robust framework for simply saying your claim is frivolous. And that claim is basically subverted if, as the district court did here, abusive process is permitted to go forward on these facts. So for example, normally when you have a situation, which was the case here, where one side says, you've harmed me, the other side says you don't, we go to trial, we both obtain experts, and the jury ultimately decides who prevails. But if the American rule and all the presumptions that entails say, ordinarily under those facts, there is no prevailing party obtaining their attorney fees. However, if you can establish that there was no substantial justification for the claim under 13-17-102, if there's a failure to certify that claim with adequate expert testimony, those sorts of statutes and the procedural safeguards and the things they entail are permissible. But here, the jury was essentially instructed that if you find that for whatever reason, that Mr. Parks was incorrect, if you find that his claims lack merit, you can also go on to essentially serve as the judge in this case and award the defendants the attorney fees that they incurred defending this case. That would seem to be undermine those policies, and it's important as a matter of record that the district court repeatedly denied the defendant's motions for summary judgment. And so as of the time that this case went to the jury, although Mr. Parks' claims were not ultimately successful, they were certainly presented a genuine issue of material fact under which, as a matter of law, under which reasonable jurors could have found in his favor. With that, I think the only other significant point I want to raise here relates to the relief requested, in addition to requesting that the verdict be vacated or reversed and that the denial of directed verdict be reversed with respect to the abusive process claim. We'd also submit that the allowance of this claim to proceed tainted Mr. Parks' ability to pursue his own claims. There's a couple of really poignant examples of that in the record and indeed in the defense's own brief on this question. The defense indicates that the abusive process could have been proven by Mr. Parks' past conduct, by his alleged reputation for filing unfounded suits, those related, ironically enough, to underlying suits in which the defendants were representing him. And the defendants characterized this as 404B evidence, as evidence that we normally don't want juries to have, as evidence that normally has strong potential to be prejudicial. That evidence was permitted to go before the jury because it was relevant to the abusive process claim. And so there's that prejudicial impact, not only with the claim itself, but also with the prosecution of the
Mr. Martin, are you
plaintiff's claims.
saying that the mere assertion, allowance of the abusive process assertion and evidence concerning it so tainted the other claims that we can't rely on the jury's verdict?
Yes, Your Honor. And of course, that's not the only basis that we've asked for retrial on our own claims, but that there's, as I indicated, there's two illustrations of that. One of them is the 404B evidence. There's also parts in the trial where multiple witnesses are told, well, this is Mr. Parks up to his old tricks, that he has a tendency to use legal proceedings for things that they're not supposed to be used for.
Well, why isn't, if CRE 404B evidence is admissible and it's actually provided, how is that prejudicial? Certainly it hurts your client's case, but how is it prejudicial legally?
Because it was only admissible in this case with respect to the counterclaim for abuse of process. This evidence certainly would not have been admissible. These sort of negative characterizations of Mr. Parks' alleged bad character would not have been admissible if this was simply a negligence claim or a counterclaim for abuse of process. And another prime example where that came up was there was a piece of, and it's referred to also in the appellant's brief, there's a piece of 408 evidence that was permitted. Again, prior to the sort of termination of their attorney-client relationship, there's an exchange of emails in which Mr. Parrish tells Mr. Parks, you owe us X amount of money. Mr. Parks says, well, it really appears to me that you made a significant mistake. It cost me a significant amount of money, and I appreciate your willingness, Mr. Parks said, to cut your fees in half, but I don't think that that makes me whole. That was clearly contemplation of litigation. It was clearly an attempt to sort of compromise the claims, but the district court not only allowed it in, but then redacted the parts with the specific numbers, redacted the parts of the claim that Mr. Parrish was not seeking the full amount of fees from Mr. Parks. And so that's the prejudice with respect to Mr. Parks' own claims, but in any event, we'd request reversal of the directed verdict on the counterclaim.
Counsel, before you sit down, I have a question along those lines. I've read the post-trial motions, and I may have missed it, but I don't recall you making this particular argument there, that we are not just entitled to judgment on the abuse of process claim, but if we are, we also get judgment on or the other claims, or you have to set aside the result. I do not recall seeing that argument made.
I don't believe that's made in our Rule 59 motion. I think that's correct.
So how is it preserved? How is it even before us?
It's preserved with the directed verdict motion made at trial, as well as the objections to those pieces of evidence coming in individually.
Well, those are pieces, but there was never an argument that the evidence on this particular claim, which should not have gone to the jury, so tainted the other claims that the verdicts on those claims must be reversed. I never saw that.
In Your Honor, it's candidly, yes, it's not there. We would stand on the briefing and indicate that that gave the court an opportunity. And I'll reserve the rest of my time.
Certainly may. Thank you. Feel free to proceed when you're ready.
Good morning.
Good morning.
My name is Dale Parrish. My registration number is 11260. Thank you for hearing this argument this morning. After we finished both cases for Mr. Parks, a divorce and a partition case, Mr. Parks wanted to appeal the partition case, and specifically, he wanted to appeal District Judge Dennis Hall's wholesale adoption of the commissioner's report, retired Judge Jack Berryhill's report in the partition case. We told Mr. Parks that in order to explore an appeal, he would have to pay the fees that we had already incurred. He had paid much of that, but that he would have to finish paying those fees. He asked that I reduce those fees, and I did so. Several days later, I received an email, it's Exhibit M from the trial court, offering a ring and some property in southern Colorado in payment of our fees. When I declined that offer, Mr. Parks threatened me. What he said was, and it's part of the record, you should reconsider this offer because I have found some attorneys who are willing to sue you. Mr. Parks was threatening me in order to have me continue as his attorney. I ended that conversation. I did file a notice of attorney's lien. We also filed a motion to reduce that lien to judgment.
Mr. Parrish, the statement, "I have found some attorneys who are willing to sue you," that has many connotations to me. As I see it, it could be a threat, as you have characterized it. It could be a mere statement that I think you committed malpractice or were negligent in your representation. You think there are different ways to see it as well?
Yes. Your Honor, I would point out that I cross-examined Mr. Parks on the fourth day of jury trial, March 24. And I began my cross-examination with asking him questions about the very thing he had just finished talking about on direct examination with his attorneys. And that is that Mr. Parks wrote a letter saying that all of the work that we had done for him was good, with one exception. He said we made one single mistake. And that mistake that he identified was the settlement of the partition, which he called an unauthorized settlement. His words were that I had him agree to a settlement to which he did not accede. That was the words that he used in the brief as well. I would respectfully point out that that settlement was a settlement that Mr. Parks himself answered questions about to District Judge Hall on the record. In Exhibit J, Judge Hall asks him about the settlement and if it's his settlement. And more important, this single mistake that Mr. Parks is pointing out, he's saying that there was an email string the night before, on December 15, between myself and Angela Whitford, who was then with Sherman and Howard, to settle the partition case. And it's true, we did that. And Mr. Parks had some opposition to using the realtors that had sold them this property, the Conifer property, the Penlands. He had some opposition to using them to do the valuation that would be submitted to Judge Barry Hill, the commissioner, in this partition case. Keep in mind that this was the other side agreeing to our counterclaim, agreeing to judgment for partition to enter on the day of trial, December 16. Well, that morning in Judge Hall's division, before he entered the courtroom, Mr. Parks again asked if we could change that language about the Penlands being the basis for the property evaluation. Remember the emphasis on the word "the," and Judge Hall actually researched the word "the." And we had a meeting, Ms. Whitford and I, behind the podium, talking about that very thing. And Ms. Whitford and her client again rejected Mr. Parks' ideas and said, no, it's going to be the Penlands, and that's going to be the basis for property evaluation. Ms. Whitford testified about this to the jury on March 23 and said, we had that meeting behind the podium, and then I went back over and talked to Mr. Parks, explained what had happened and the language, and Ms. Whitford said that she watched that. That happened before Judge Hall came into the courtroom and made the record regarding that. So if that is the single mistake that Mr. Parks alleges, I respectfully submit to you, Your Honors, that that's not only not true, that never was a mistake, that Mr. Parks knew exactly what that settlement involved, and he answered questions on the record about that. But when he argues that, I'd like to get the exact language, that the breach of the duty of loyalty for Parrish was to bind his client to a settlement to which he expressly declined to accede. That argument in this appeal should net us appellate attorney fees. That's a wrong, false argument. It lacks substantial justification.
Counsel, you're arguing the facts. That never went to the jury. That claim never went to the jury because it was dismissed. we're not in a position to make that kind of a call.
I asked for attorney fees in my answer brief, and I'm asking you to consider that request because this argument by the appellant in this brief completely is contradicted by the record made by Judge Dennis Hall. I did not bind my...
Counsel, we don't make credibility findings for the first time on appeal. We just don't do that.
understand.
The argument you're making now doesn't have anything to do with the legal issues on that claim. This is an appellate court, and I'm sorry, but we'd like to hear an appellate argument,
Yes, Your Honor.
not a closing argument.
I apologize.
No, that's all right.
So, with respect to the threat that was made to me before he filed suit, that threat and how he carried it out by filing suit was likened under Rule 404B to the same threat that he made to Angela Whitford and Susan Walton to file a divorce action if they did not agree to his settlement position with respect to the partition of the property. This was before any lawsuits were filed, and Ms. Whitford also testified about that. To your point about Rule 404B, it was relevant under Rule 404B as a coercive pattern of conduct, but it was also relevant to the common law marriage question. Remember, Mr. Parks threatened to file suit for divorce if they didn't agree to his terms on dividing the property.
Well, can I shortcut this? I mean, I think, as I understand the law, you clearly were entitled to introduce evidence concerning intent and concerning impropriety. But the question now that I have is, how is an assertion of negligence on the part of an attorney necessarily an abuse of process, generate an abuse of process counterclaim when in fact the issues went to the jury? There was sufficient evidence both ways to get to the jury on these issues.
The answer is based on three different cases that were briefed. Van Lanningham, active release techniques, and Mintz. The abusive process claim does have three prongs, and it's true that appellant has argued that it's the second prong that is lacking here, improper use. And to quote our brief, it is improper use to file a cognizable claim to accomplish a coercive goal. And that's Walker versus Van Lanningham. ART said that the abusive process can be an otherwise meritorious claim. And Mintz said that that abusive process can take place before the cognizable claim is filed. So the coercive goal was he was trying to get me not to lien, to file a notice of attorney's lien, and he was trying to get out of paying the fees that we had incurred in defending him and handling those two cases.
But counsel, isn't that precisely one of the damage, those are damages that are recoverable in a legal malpractice case? That I do not have to pay my lawyer, he's seeking fees from me, but he committed malpractice, so I don't have to pay him. And that's what happened here. I mean, he brought a case saying, I don't have to pay these fees. That's a valid malpractice theory, and you're saying that's what he was trying to achieve.
Remember, Your Honor, there were two cases, and he only alleged one single mistake in the second case, the partition. He was trying to get out of paying all of his fees, and he was saying he was going to do that because he had found attorneys who were willing to sue me. Now, all of the prongs of abusive process are met by this case, and the jury so found. And the jury found because the jury heard this evidence about Mr. Parks threatening lawsuits to gain an improper goal, to coerce a goal. And that coercive goal is exactly what Walker versus Van Lanningham cites as the second prong, improper use or manner.
Well, anybody that asks for a judgment in their favor against an opponent is certainly seeking a coercive goal, are they not? They want the court to say, Mr. Defendant, you owe Mr. Plaintiff money. So there is a coercion part in the actual bringing of a lawsuit, is there not?
It has to be collateral, a collateral advantage. He's asking.
But he asked here not to pay your fees.
No, that was, his claims were breach of fiduciary duty and breach and negligence.
And as a
so-
result of that, he said, I shouldn't have to pay not only Mr. Parrish's current fees that I hadn't paid, But my prior fees?
Those issues were before the jury based on my counterclaim for breach of contract for his failure to pay my fees. He did not make an issue of not paying my fees in his negligence or breach of fiduciary duty
But I mean, in
claims.
his claim, a malpractice claim has to be supported by damages. And the damages here that he asserted, as I understand it, are, I had to pay.
I would respectfully remind the court that Mr. Parks was actually threatening me in order to have me continue as his attorney. So he wasn't originally threatening me to not pay my fees. He was offering to pay my fees with some other property. But it wasn't to not pay my fees that he was threatening. He was threatening me in order to get me to appeal or explore appeal of the partition decision made by Judge Hall. And in response to that, we took the position, don't you need to pay our fees that we've already incurred? And in response to that, he said, take this offer. And when I said no, he said, no, you should take this offer because I've found attorneys who are willing to sue you. He didn't say, I found attorneys who are willing to sue you so I don't have to pay my fees. He didn't say anything specifically about.
Seems like a pretty fine distinction. I'm not sure I understand the difference, but thank you for your argument on that.
And I don't have anything else. Those are the facts of this case.
Mr. Parrish, under your view of the three prongs of the abusive process claim, what's the difference between the first and the second prong?
It's pretty thin, I would admit.
Is there any under your theory?
No, not under my theory. The first prong is ulterior purpose. The second prong is improper use. And the improper use, the second prong, is satisfied if you show a coercive goal to harass, to increase our fees. These are things that we argued Mr. Parks did by suing us.
But don't those things go to the first prong, ulterior purpose of the whole proceeding?
You can see it that way, and I don't disagree with how that looks. But there are separate prongs, and those three cases I just cited to you all address the coercive goal or the harassment, the delay. The ulterior purpose is similar, but it's the collateral advantage he's seeking to gain that satisfies the second prong.
Counsel, but you're relying on that one quote from Walker, but about the coercive goal. But Walker also says that coercive goal has to be, quote, again, to accomplish a purpose that the proceeding was not designed to achieve, end quote. So it can't be just any coercive goal. It has to be something independent, something collateral to something the process itself is not designed to achieve. But you're alleging that he is seeking, through this action, not to have to pay your fees, and that's precisely the purpose of a malpractice action.
I'm alleging that he's trying to get out of paying my fees as the collateral advantage. His two claims were for damages for my negligence.
But under your theory then, every single time a client sues for malpractice, the attorney has theoretically, and perhaps in practice, a counterclaim for abusive process, every single time.
Only if the client says, no, you should reconsider my offer to pay your fees in some other manner because I have now found attorneys who are willing to sue you.
So if there's been settlement discussions and a threat to sue, then you have an abusive process claim?
Remember, the suit that he filed was not to get out of my fees. He filed suit for negligence and breach of fiduciary duty to get damages against me for mishandling his case. And I would like, since I don't have any more time, thank you very much.
Thank you, Mr. Parrish. Mr. Martin, you have 2 minutes and 5 seconds.
Thank you, Your Honors. May it please the court. I'd like to address three issues on rebuttal. The first relates to the appellee's request for appellate attorney fees. We'd object to that request, and this was borne out in the briefs. First of all, on the simple basis that it's procedurally deficient. The request for appellate attorney fees in this case was not accompanied by any argument or any identification as to how, under this court's precedence, when appellate attorney fees are awarded, they'd be warranted here, and there's other case law cited in our briefs indicating that the failure to even make that analysis is sufficient basis to deny those claims. The factual disagreements or the sort of record disputes that the appellee raised in response were not only things we disagree with, not only things that are basically irrelevant to the issues before the court, but they also weren't preserved. And so for that reason, that request should be denied. Second, there's a pretty important concession in the appellee's answer, which is that he said, not under my theory. Under my theory, there isn't a distinction between improper use and improper motive, but the case law is painstakingly clear that there needs to be. And not only does the case law bear out that attorney negligence is a valid defense to a claim for legal malpractice, but the defendant admitted as much in his response to the request for request for admission. Finally, the point I'd make is that if it's true, the sort of theory that somehow Mr. Parks' exchanges prior to this lawsuit being brought prove that it was to accomplish a coercive goal were true, then the entire damages would necessarily have been different. The damages sought for the counterclaim were for the defense of this claim, which wasn't pursued abusively. For those reasons, we'd urge reversal. Thank you.
Thank you, counsel. Thank you to both counsel for your arguments. They were helpful to the court, and the case will stand submitted, and a written opinion will issue in due course. Counsel in this case are excused. That concludes our morning docket. The court will be in recess, and the bailiff may so announce, please.